Hello, landlords. It's Ernie Garcia, landlord attorney. And today we're talking all about your security deposit and the 7 ways that landlords misuse that deposit. Let's get started. Most landlords understand that a security deposit is an important feature in their lease. However, where landlords tend to get themselves in trouble is with the idea of exactly how to use the deposit or what the deposit is precisely for. In a nutshell, the deposit is security for you, the landlord, at a time when the tenant is no longer around. And specifically, you want to wait to use any portion of your deposit until after your tenant has vacated. Essentially, if you don't have access to your tenant and their ability to compensate you for problems that occur during the tenancy, then the only thing you have left is your security deposit. If that deposit has been depleted, and we're going to talk about the numerous instances when that happens, if your deposit has been depleted, you have less security upon which to rely, and that leaves you in a pinch when things go really off the rails. So the first thing we're going to talk about is late fees. And I get it. For many landlords, you sidestep this issue by just saying, well, I don't charge late fees anyway. And so because I don't charge them, they're not an issue for my security deposit. But for those of you who do charge late fees, and it's something that I encourage, I believe it actually makes for a better tenant. For those of you who are charging late fees, but you're doing it wrong, you're not actually insisting on prompt payment and proper payment. Here's what I mean. Some landlords will tell their tenants, look, you've paid late. You paid late in January, you paid late in April, and now you've paid late in June, and I'm deducting all of this from your security deposit. And I got to tell you, this doesn't sting the way it would if the tenant is immediately paying for these fees. This tenant may be convinced, look, I wasn't getting my security deposit back anyway. And because of that, it's essentially no harm to me to have paid late. I guess this is what the security deposit is for. And don't I feel great having this backup system? But that's not the way a security deposit is meant to work. Every time you deplete the deposit by pulling late fees, you're essentially letting the tenant off the hook. Your lease should inform the tenant that you can pull late fees from the next month's rent. Now, this is available if you have what's called an application of funds clause, so that in the next month when rent is paid, if late fees were owed from a prior month, you can pull from there. And at that point, you are more secure. Your security deposit is intact for when the tenant leaves at some point in the future. And you've recovered those late fees, but your application of funds clause tells the tenant that you can pull owed amounts from the next payment and they still owe rent. Remember, you can't evict for unpaid late fees, but you can evict for unpaid rent. And so you put the onus back on the tenant to become current. Now, for those of you who are not charging late fees, but have a tenant who, for example, fails to pay the full amount of rent, when you are depleting your security deposit to make up for that gap, again, you are bailing a tenant out, probably a tenant who doesn't belong in this tenancy. You're bailing the tenant out and further reducing your own security. You don't want to pull rent payment from the security deposit, whether that's an entire month because they just couldn't make it this month. And so there you go, rescuing your tenant by using the security deposit. Or they tell you, I'm about $500 short. Can we just pull it from the security deposit? In fact, many leases prohibit any amount of rent being applied by the tenant toward their rent payment from the security deposit. And so make sure that you're holding your tenants to their agreement. And if for whatever reason they cannot make a payment or they cannot make a full payment, that you are not harming yourself potentially by reducing your security. Make sure that if the money is going to come from anywhere, it's from your tenant. Even if it comes late, assess those late fees. Make sure that rent is ultimately paid, but do not waive it and do not pull it from your security deposit. Make sure that your tenant is paying everything that is owed every single month. And if not, that's when you issue a notice to vacate. Another matter where landlords tend to let tenants off the hook has to do with repairs. Little Jimmy was playing baseball and broke a window. You went and repaired it. This has nothing to do with the disrepair of the home, which would otherwise be on the shoulders of the landlord. This is something that the tenant caused. Perhaps the tenant had a fire in the kitchen and caused significant amount of damage. And you say, well, I'm glad I have that security deposit on file because I can just pull from there and pay toward the damage caused by the tenant. But that's not the way your lease is meant to operate. Make sure you've read your lease. Does your lease require that the tenant pay for repairs for things that were caused by them and them alone? Hopefully it does. And if that's the case, then you can tally up the costs, and at the next time the rent is due, you can send your tenant that bill. Their failure to pay that bill doesn't mean, again, that you're bailing them out by pulling the funds from the security deposit. Instead, it's the responsibility of the tenant to pay for these fees, just like it would be anywhere else. If they cause damage to a third party, they're required to pay. In your case, however, you also have the added strength of your lease and the ability to enforce its terms. So make sure you are not, again, depleting your security by pulling funds from your security deposit to pay for repairs that are solely the responsibility of your tenant. Landlords, as always, we welcome you to follow us on our Instagram page. If you're not a member yet, join us on Facebook. And if you enjoy what you see here, give us a thumbs up. Click that like button. We enjoy that very much. And if you haven't subscribed yet, please consider subscribing. So next I'm going to talk about two ways where landlords get themselves into trouble by misusing their security deposit funds. One way that landlords do this is simply by failing to return the security deposit. Did you know that Texas law requires that you refund a tenant's security deposit? If you didn't know that, you might have some future lawsuits headed toward you. The Texas Property Code is very clear, and many tenants are quite aware that the landlord is responsible for returning the security deposit. In fact, you've got 30 days from the date that the tenant vacates the property to either issue a refund or to send an itemized report of how the deposit was used, or to refund the portion that was unused along with an itemized report of how the other part was applied to these costs. You have to care for the security deposit that is entrusted to you by your tenant and then keep proper records of it. If you're unable to supply this within the 30-day limit, you might be subject not to the amounts that are owed from the security deposit. You might be subject to a full return of the entire amount, being unable to deduct any portion that would otherwise have been a valid deduction. Additionally, you might owe statutory damages to your tenant in excess of the deposit itself. Finally, you might be required to pay attorney fees and court costs if the matter ends up in a Texas court. These are all things you can avoid if you simply handle the deposit properly at the end of a tenancy. Make sure that you either A, return the full amount, B, return a portion with an itemized listing of each of the proper deductions, or C, simply return an itemized listing of all deductions because the entire amount was used in a proper way for fees properly applicable to the tenant's security deposit. Now, for those of you who are aware of the obligation to return a security deposit, what you may not be aware of is where the line exists for normal wear and tear. Here's the truth. we sometimes want to assess all sorts of costs to our tenant that simply are not applicable. So here's the classic example, the carpet. When your tenant first arrives into your home, the carpet has been there for 5 years and it's still in pretty good condition. But after 3 years, the tenant leaves and the carpet is done. It has no life. It cannot be reused. And so throughout the whole house, you have to rip up carpet and apply new carpet. And so in your mind, you're thinking, well, I get to charge him the full fee because now I have to replace all of the carpet in the entire home. Thanks, tenant. Your security deposit is gone. However, you didn't get brand new carpet in that unit when the tenants arrived. In fact, you had carpet that was 5 years old. And the fact that it was in pretty good condition doesn't mean you're allowed to charge this to the tenant. If after 8 years, anyone can reasonably say that the life of that carpet is done through normal use or normal wear and tear, there's zero value in that carpet after 8 years. And so if it had zero value, you can charge only zero to a tenant if you have to replace it. The same is true with a scuff on a wall. Let's say, for example, you have one room with one scuff on the wall, but you decide to resurface the entire wall and repaint the entire wall and charge all of that to your tenant. Chances are pretty good that the court simply isn't going to allow that is excessive for a single scuff. If you elect to go above and beyond, you have every right to do that, but you can really only charge your tenant something that is reasonable. The idea that you would have to charge for the entire room, both to be resurfaced and to be repainted, probably goes too far. And usually I tell landlords, you're going to want to limit that cost to what is reasonable and necessary. And you're going to want to take into account whether or not that scuff itself was from normal use or normal wear and tear. It's actually possible, depending on the surface, depending on the use. But these are considerations you have to make. Am I charging too much for the job? And am I considering normal wear and tear? These next two topics have to do with the beginning of the lease. First is the landlord simply requesting an insufficient amount of security deposit. So generally speaking, a good security deposit is 1 month of rent. However, this amount may be insufficient for your particular tenant. If, for example, the creditworthiness of your tenant is suspect, you might have to consider a significantly higher deposit amount in order for this to work. However, sometimes landlords don't even consider 1 month of rent a proper security deposit, and they do something significantly less than that. I would say that if you don't have at least 1 month, you are insufficiently secure for your tenancy. Make sure you're charging at least 1 full month of rent. The other thing that doesn't make sense to me that landlords do at the beginning of their leases sometimes is they give an opportunity to the tenant to pay their security deposit over a number of months. They agree to some payment plan and allow the tenant to pay the security deposit over time. What I see happening in this situation is that sometimes, yes, the tenant does in fact comply with all the payments and the security deposit is paid. But many times I see that maybe 1, maybe 2 payments come in, but the full amount is never paid. The truth is, if your tenant cannot pay the full amount of a first month's rent and the full amount of the security deposit, you've probably chosen a bad match. And so the fact that they can't pay it should be an indication to you that they can't sign the lease. in any case, you shouldn't allow it because you are already insecure right from the start. And because you know this, you probably know that at some point in the future, they're also going to have difficulty completing a payment. They're showing you up front they simply cannot pay. And because they can't afford to pay what is owed, it is very likely that in the future, you will find yourself in a similar spot. That's too much information for you right from the start to disregard. If your tenant cannot pay the full amount of security deposit, I don't recommend you entering into some kind of payment plan with them. You should simply base your denial on the fact that the tenant cannot pay what's owed at move-in and move on to the next eligible tenant.